Got a quarter?
Due to the graphic nature of the following program, viewer discretion is advised.
Are we proceeding with trial today?
Your Honor, at this time, Ms. Palmer wishes to enter a change of plea to no contest to both counts of the complaint.
Okay, you're talking about case number ending in 017. Well, thank all our witnesses for being present today. It does help resolve things. I know Ms. Palmer, the jail yesterday initially would not accept Ms. Palmer due to her condition, so she went to the hospital. And then, were you returned from Metro? Were you treated at Metro and came back? All right, so I guess that made the jail happy. Ms. Palmer, count 1, soliciting. This is a misdemeanor of the first degree, carries a minimum mandatory fine of $400 and minimum mandatory 10-day jail sentence, with the maximums being $1,000 and up to 180 jail days. That's for a first offense. You understand that? Can you hear me?
Yeah.
All right. Do you understand what I just told you?
Yes.
All right. Just so you understand, on a second offense, the fine stays the same. It's a minimum mandatory fine of $400 with a minimum mandatory 20 jail days, and then a minimum mandatory 30 jail days for a third offense. So it escalates. So once you've pled to a first offense, the next conviction, if you get one, would be a second offense with a mandatory 20 days and up to 180. You understand? Okay. You have the right to a trial by jury or a trial to the court. All the witnesses are present today. If you change your mind and want a trial, I'll have you brought over to the court. We'll have a trial today. Do you understand that?
Okay.
Well, my understanding is you want to plead. You don't want a trial. Is that correct?
Correct.
All right. Are you waiving reading of the facts? Mr. Haller, facts are waived. A no contest plea, Ms. Palmer, is not an admission of guilt. It is an admission to the truth of the facts contained in the complaint. This plea cannot be used against you subsequently in any civil or criminal proceeding. Do you understand that?
Yes.
If you wish to enter a no contest plea to count 1, soliciting, please state no contest.
No contest.
All right, now count 2, possession of drug paraphernalia. Misdemeanor of the second degree. Maximum fine is $750, up to 90 jail days. Do you understand?
Yes.
You're giving up the same trial rights by entering a no contest plea to this charge. You understand that?
Okay.
Yes?
Yes.
Okay. If you wish to enter a no contest plea to count 2, possession of drug paraphernalia, please state no contest.
No contest.
I accept both of the no contest pleas. I do make a finding of guilt on each based on the facts contained in each respective complaints. The facts were waived. Nespa, Mr. Haller.
Yes, Your Honor.
Thank you. It's with regard to the sentencing of this matter, it's the court's understanding that you did not wish to participate in the court's fly program. And so I will just create a straight sentencing plan for you. Is that also correct? You don't wish to participate?
Ms. Palmer, that was the human trafficking docket we spoke about initially.
I haven't heard an answer from her yet. Can you hear me, Ms. Palmer?
Yes, okay, what are you asking me exactly?
Okay, I'm asking you if I am going to sentence you on this, on these charges. If you want to participate in the FLY program, if you've changed your mind, I'll put you in it. If you don't want to, that's it.
That's fine.
I say if you don't want to, I can make another plan for you. So don't do it to appease me. Do what you think you can do.
That's fine.
All right.
Participate.
All right. So it's 2 years active. Miss Karen?
Yes, Judge. Judge, I've been informed that more counseling will be at the county jail tomorrow to complete the screen and the assessment.
Okay. So Miss Palmer spent a number of days in jail. Mr. Haller, do you want to talk to the court about? I'm just going to go ahead and sentence her right now.
No objection, Your Honor. I would ask that she receive 31 days credit. She has 29 days originally, and then
Okay.
yesterday and today,
Okay.
31 days.
Okay. She's certainly done her mandatory 10. Okay, so credit for 31 days. I'm going to order some days into execution, Miss Palmer. I don't want you to panic over that. The reason for it is that more counseling is going to come and see you tomorrow, the counselor from the treatment place. They're going to talk to you, and they're going to make a plan for you, whether you need to go to residential treatment or just outpatient treatment, whatever it is that you need, they're going to make the plan for you. And once there's a plan in place that you've agreed to, I will order that you can be released to go to treatment. Do you understand?
Not exactly.
Okay, well, remember when I released you from jail the first time and you came for trial yesterday and you were under the influence of drugs? So what I want to do is keep you where you are until the counselors see you, and then they'll make a recommendation to me as soon as they've seen you or within a day. And they'll say either release Miss Palmer and she's going to go to outpatient treatment, or they're going to recommend that you live someplace like Jordan House and go to outpatient treatment, or they're going to say maybe you need to go to inpatient treatment somewhere. I don't know if you're addicted or not. I could hazard a guess, but this is not about guessing now. This is about helping you get better. So I don't want you to panic when you hear I'm executing days. It's only to allow the counselors to get in there and see you and make a treatment plan. 2 years.
How long does that take?
They're coming to see you tomorrow, ma'am. I just explained to you it will be within a day of the time they see you. They'll have a plan as soon as they've seen you. Just take one thing at a time here. 2 years active probation for the FLY program, and may be released to treatment. Anything further from either party?
No.
All right, Ms. Palmer, I look forward to working together. I've had a rough start with many people, and we wind up getting along just fine. Hi, Melissa.
She was in jail yesterday. Anyway, she hasn't been in jail.
Mr. Haller is here to represent you.
Why would she say?
Well, she wants to be the human trafficking. She wanted
This is
plead today.
Judge Early who sent you over here.
This is a screen, Judge.
Okay. All right, Ms. Karen, anything
Judge, I've been informed that more counseling will be in the county jail tomorrow to conduct a screen and assessment on Ms. Ayers. She has not been admitted to the program as of yet, as she needs a screen.
Well, and she has a not guilty plea going. So how do you want to do this, Mr. Haller? I'm going to retain her in the jail for at least a few more days. She's on no bond. I'll set a bond today, but my expectation is that unless somebody...
Can I have a personal today so I can get my house together?
Well...
Let my family know what's going on.
Well, Miss Melissa, I'd like the counselors to come and see you and make a recommendation. If the counselors that are coming to see you for more counseling recommend a personal bond, then I'll be happy to grant one. But I don't know what they're going to recommend. They're going to come and see you tomorrow. Tomorrow, they're going to come and see you.
Why?
Because you need some help. Because you need some help. Judge Early felt you need some help, and I'm guessing just based on the charges you need some help, but we'll find out some more.
What charges do I have?
You're charged with soliciting, a misdemeanor of the first degree.
That's all.
Well, there's another indication that you need some help.
What, mental illness?
Well, that's not a crime to be mentally ill,
Your Honor,
Mr. Haller.
When
Miss Melissa, I need to speak to your attorney right now, okay?
Your Honor, Ms. Ayers is very interested in participating in this court's human trafficking docket. I apologize for my own anger. Is she able to be screened and then plea maybe tomorrow?
Yeah, we could put her on a one-day pass? Well, it'd have to be Thursday. Are we here? Are we in here? We could do it. We could put her on Thursday morning.
I can come right in the morning.
Yeah, what's the date on Thursday? All right, Miss Melissa, I'm going to give you I'm going to see you again on January 17th, which is a couple of days from now. And no, 5,000 cash surety. I want to know what the counselor, 5,000 cash surety.
So what's that going to mean?
It means that somebody has to call a bondsman.
Please.
It's going to be
I
all,
haven't been in no trouble, Judge.
Miss Melissa, the counselors are coming to see you tomorrow. Okay, I need you to step out. I will see you on Thursday when I have a recommendation from the counselors.
Then I might be able to get a personal band?
Yes, you might be able to, or you might be able to be released to go to treatment or to a nice place or somewhere to live. Yeah.
I have somewhere to live.
Well, we're going to talk about it. I need to find, I don't know that. I have to find all of that out, Miss Melissa. Could you step out and I will see you on... The counselors are coming to see you tomorrow. I will see you on Thursday. Step out, please. Step out, please.
And then I can maybe even have time served by the time I get to court.
Well, I just have to talk. You have to talk to your lawyer, and I have to talk to the counselors, okay? We have to do this all together. You're presumed innocent. You're presumed innocent. Miss Melissa, you're not going today. Step out, please. Please step out, Miss Melissa. Thank you. It appears, Mr. Monson failed to appear for the PSI interview.
He was taken involuntarily to LCI for sanction
Oh,
from October 11th to November 30th. I think that was the cause of it.
till November 30th.
Was it November 30th?
I got released November 30th, ma'am.
I guess the city's question is, like, because we were here October 2nd, he pled on October 2nd, was given a personal bond, and if it's my understanding, he went to LCI October 11th. Okay.
That, I have a note here that we were here on December 19th.
Yes, Your Honor.
So I apparently wasn't aware that he had not seen probation. Does Mr. Monson want an opportunity to, I think we should, since he's been to LCI, should probably have this updated. I don't know why I didn't do that in December. Mr. Haller, do you care to weigh in on that? Do you think it makes sense to have him, or if you can explain to me why he went to LCI, on what sanction, for what reason, I guess that would be helpful. But there's no information. This is just a background.
Generally, let me talk for a minute, okay? It's going to be okay. He's really eager to speak to the court, Your Honor, but I've spoken to multiple parole officers on this issue, and I've been told every time their policy is if there is an offense of violence that's pled to of any level, once the jailed defendant becomes available, they are taken without exception to LCI for sanction hearing.
Oh, okay, so.
And that's, I think a personal bond was granted. This is an offense of violence, and he was taken out for the sanction.
Okay, and how?
this particular incident actually happened 3 weeks after him being released from prison. He picked up this case and a DUS.
All right, I'd like to give Mr. Monson a chance to speak to probation.
Okay.
As much as I'd like to sentence this and be done, I think there's enough complicating information. Is there something briefly you wanted to tell me, sir?
Yes, Your Honor.
I'm not sentencing you today.
Yes, Your Honor. I'm currently working. You know, I'm trying to do the right thing, and I just want to ask, you know, like, with all the respect, like, I haven't had no contact with the victim. And
Good. Don't have any more.
She's currently pregnant, and I want to know if I can lift the contact order. I don't got
No.
no problems with her.
I absolutely will not lift the no contact order. Not right now. You're gonna go down and see probation. We're gonna do one thing at a time.
Yes, Your Honor.
This offense happened way, the progression of events is a matter of concern to the court. Do what's best for you right now. Stay away.
Okay.
Sentencing, we can update this. February 5th at 10:30. All right, so go down to probation now. Have a seat outside and go down to the, are they going to direct him or does he just go? Have a seat outside and we'll tell you when to go to the 6th floor to talk to probation so you can have input into the report about you. All right, thank you.
Good morning, Your Honor.
Good morning, Ms. Stark.
For the record, Irene Stark, Ohio Supreme Court Certified Court Interpreter 201-501-575, and this interpreter remains on the oath.
Thank you very much.
You're welcome, Your Honor. Para que conste en acta, Siriana Stark, intérprete certificada por el Tribunal Supremo de Ohio 201-501-575. Este intérprete permanece bajo juramento.
Your Honor, Jason Heller on behalf of Mr. Torres. He was screened and found eligible for DJP, but there is a plea offer prior to that.
Oh, okay.
May I, Ms. Powell?
Well, now we lost Ms. Powell.
Your Honor,
Yes.
I believe this matter had previously been sent for a DJP screen back in December of 2018. Cities understand that he is eligible for the program.
So it would appear. Is there a plea agreement prior to placement?
Yes, Your Honor. The city is going to amend the domestic violence to Cleveland Codified Ordinance 605.03, the aggravated disorderly conduct misdemeanor of the first degree. City's understanding the defendant will plead guilty to that amended charge. Based off of that plea forthcoming, city would nolly the balance. City would ask for the domestic violence counseling. We would also ask for no new convictions, no new police reports. We have spoken to the victim on in this matter on a couple of prior occasions. Regarding the incident and also the referral to the program and so forth.
Hey, please, if you have to yawn and stretch, just step out, because it's disruptive to us here. Is the victim, what is the victim's wish? Is the parties are married, are they not?
Correct, they're married.
So
there is a protection order. This is the case, because this has been around for a minute, that they work at the same facility and they were in either different parts of the building or different shifts.
I think given the fact this is the DJP program, I would be inclined to
She had previously asked for the protection in order to lift, but we stated that that would not be presented prior to the screen coming back.
All right, so Mr. Haller, M1 ag menacing, is that your understanding?
Aggravated disorderly conduct.
Oh, ag DC, I'm sorry.
And the purpose for that is he's a non-citizen Cuban national for residency.
Oh, okay, so I got to read him the, thank you. Okay, Mr. Torres. Count 1 has been amended to Cleveland Codified Ordinance 60503. This is a misdemeanor, the first degree aggravated disorderly conduct. Maximum fine is $1,000, up to 180 jail days. These are the maximum possible penalties. Do you understand that?
Yes.
You have the right to a trial by jury or a trial to this court on the original charges pending against you. You're giving up that right today. Is he pleading guilty or no contest?
It's a plea of guilty for the DJP.
Okay. By entering a guilty plea to this amended charge. Do you understand, sir? You're giving up your right to a trial by entering into a plea agreement. Okay, thank you. Are you waiving reading of the facts?
We are.
Thank you. Facts are waived. I am obliged to inform you, Mr. Torres, that if you are not a citizen of the United States, you are hereby advised that conviction of the offense to which you are pleading guilty may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Do you understand what I've just told you, sir?
No, I don't understand.
All right, the law requires that I read you this statement just the way it is written, but I will do it again, and then I will try to explain. All right. If you are not a citizen of the United States, you are hereby advised that conviction of the offense to which you are pleading guilty, that is aggravated disorderly conduct, may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. What this means, sir, is that because you are not a citizen, a plea of guilty to this offense could result in your deportation from the United States, or if you were to leave the United States and attempt to come back, they could exclude you based on this conviction. Or if you sought to become a U.S. citizen, the government could tell you no because of this conviction. It is my understanding that your attorney has worked to make sure that the offense to which you are pleading would not cause those results. If you have questions about that, please ask Mr. Haller right now. That's Mr. Haller right there.
One moment, Your Honor.
Sure.
This is what we talked about. Thank you, Your Honor.
Okay. All right, so, sir, if you wish to plead guilty to aggravated disorderly conduct, please state guilty.
Guilty.
Thank you, Ms. Stark and Mr. Torres. Okay. I accept the guilty plea, and on today's date, I do not make any finding of guilt. The court is placing you in the deferred judgment program,
January 15, 2020.
ordering domestic violence counseling. Next court date is a year from now, January 15th, 2020, 9 o'clock. And you're not to pick up, there to be no new police reports about anything, no new convictions of any type, and successful completion of this program will result in the city nollying this case and the record being sealed, so there will be no conviction. All right, so I wish you a lot of luck. Go to, the court will accept DV counseling from an agency that will do it in Spanish.
The city was going to just make two clarifications, just to say, I know in certain situations, instead of diet, they do the equivalent number of hours of counseling, and due to language barrier issues, the city would just
I think Catholic Charities actually has a program that.
And then
not to interrupt, but he's involved with Catholic Charities
right.
now for a number of years.
Okay, good.
And then the second clarification, just for the record and due to the extenuating circumstances here, that 605.03 under the Cleveland Codified Ordinance Section A is the no person shall recklessly cause inconvenience, annoyance, or alarm to another by doing any of the following, which is engaging in fighting, insulting, taunting, challenging, making unreasonable noises. Under the E section, it becomes, if one persists, it becomes aggravated disorderly conduct,
So it's
M1. So it's 605.03A.
Okay, got it. I'll make it 60503A.
Is the TPO in effect?
Thank you. I'm going to terminate the TPO.
Okay, it's terminated.
So the TPO is terminated. You may have contact with your wife, and I would, you know, there is no order in place preventing that. You're in a program that presumes you're going to do the right thing, Mr. Torres.
Okay, thank you.
All right, thank you.
For a videotape copy of this episode, call 664-3571 with the following information on your TV screen.